In January 2017, we saw the EU Commission propose a e-privacy regulation to replace the e-privacy directive, with the ambitious aim of a new regulation being in place in May 2018 to match up with the GDPR applying. And that seemed quite optimistic and quite ambitious, and certainly even more optimistic and ambitious by October, which is the point at which the EU Parliament adopted its report. And I think, as we all know, that deadline has not been met. We don't quite know when the EU Council is going to adopt its general approach, and again, Elizabeth will fill you in there. But it may well be that we won't see the new e-privacy regulation until 2019, and we might not even see it before May 2019. May 2019 is an important date because that's when the EU Parliament elections take place, so if the law isn't in place by then, possibly it will be delayed even further. And for the purposes today, we've looked at the EU Commission's proposal, the EU Parliament's report, and the draft from the EU Council that was issued in May this year. There are lots of other drafts, and they say lots of different things. So it's a bit tricky, really, I think, to talk about e-privacy because we don't really know what it's going to say, and it might not come in for some time. There's certainly a possibility that if we have a no-deal Brexit in March next year, that the e-privacy regulation might never apply to the UK. And so to try and make the talk today a little bit more interesting and a bit more relevant, we thought we'd also talk about e-privacy 1.5, which is here and is now. And e-privacy 1.5 is the changes to the existing e-privacy directive brought about by the GDPR. And in fact, those changes are quite significant and bring around much of the effect of e-privacy 2.0. So what is e-privacy 1.5? Well, within the e-privacy directive, there are various obligations or possibilities to obtain consent. And we know that the definition of consent in the e-privacy directive is taken from the Data Protection Directive by virtue of Article 2 of the e-privacy directive. And we know that references to the Data Protection Directive are now references to the GDPR. And so effectively that means that it is quite possible that when we talk about consent in the e-privacy directive, we're now talking about GDPR-style consent. It's not completely sure because we have Article 95 of the GDPR that says this regulation shall not impose additional obligations on natural or legal persons in relation to the processing in connection with the provision of publicly available electronic communication services in public communication networks, which are subject to specific obligations in the privacy directives. Now, I'm not absolutely sure quite what that means, but we know what the Article 29 Working Party thinks it means, and the Article 29 Working Party thinks it means that this does not remove the heightened requirements for consent. So the Article 29 Working Party now thinks when we talk about consent in the privacy directive, that needs to be GDPR standard consent. What does that mean in practice?
So you've probably all seen blogs like this on Twitter. And what are people talking about? They're talking about the dilemma of reconsent, or as other people might call it, the worst spam in history, allegedly caused by the GDPR. Now, is it GDPR that wrought this disruption? To think about that, it's useful to think about the position now. So the position we're in, which is a kind of limbo. So we have lots of clients saying to us, what shall we do? We were hoping just to update our marketing strategies. So if we take email marketing as an example, once we didn't want to have to update for GDPR and then the new e-privacy regulation. But actually, that's the situation we're now in. So the first thing to make sure about is that we understand that there are two regimes that currently apply to marketing emails, to take those as an example. There is the GDPR regime and the e-privacy directive regime, which both run in parallel. So you can't think about one without thinking about the other. So on the GDPR, yes, consent still is a legitimate basis. to send people marketing emails, but that is a much higher standard of consent. There needs to be a clear affirmative action. So those pre-tick boxes that people used to use are no longer okay. There are other solutions, though, explicitly provided for a legal basis for processing under the GDPR, so legitimate interests. So if you are able to perform your legitimate interest assessment and come to the conclusion, taking into account things like the recency of your last contact with an individual, the frequency of your proposed marketing campaign, whether you offer opt-outs, how you deal with suppressions, etc., and you come to the conclusion that that is in the legitimate expectation of an individual, yes, you can rely on legitimate interest as a GDPR ground for processing for direct email marketing. But that doesn't exempt you from the provisions of the e-privacy regulation, which require you to get consent when you market to individuals in some circumstances. So you will need consent unless you fall under one of these exemptions. So unless you fall under the similar products and services exemption, which still requires you to evidence that you provided an opt-out, both when you collected data and thereafter, and actually doesn't really work for cross-group marketing. So lots of people wrongly use that exemption to market between different legal entities within the same group. You can't do that. You can't also use that exemption of your charity. There's also in some member states, so in the UK, but definitely not in all member states, there is an exemption for corporate subscribers. So if you're marketing to Peter Church at Linklaters.com, you need to offer an opt-out, but you don't necessarily need to get his consent up front currently. So to give you an example of why some of these reconsenting emails have gone out and why there's been a bit of a deluge, here we take a charity who has historically relied on a pre-ticked box. So what do we know about that? Well, we know that that won't be GDPR compliant consent. And let's be nice to the charity and assume that they have done their LIA, the legitimate interest assessment, so they can rely on legitimate interest under GDPR. What happens under the privacy directive now that we have to move to the GDPR sort of compliant consent box? Well, actually, it means they need a reconsent because they don't have GDPR compliant consent. They can't use similar products and services because they're a charity, and they're certainly not just emailing corporate subscribers, they're emailing individuals, so they must reconsent. Now, that's not to say that everybody who has undertaken a reconsent exercise actually needed to do it, and they certainly didn't need to do it by sending 10 emails, each one more frantic than the last, saying, really, do you want to leave? This is your last chance. So, look, some of the reconsenting we've seen has had unintended consequences. We've seen people go out and get reconsents where they didn't actually need them. They've had 98% dropouts, some of them we hear, from their marketing lists. And actually the worst position to be in is having done that exercise to now decide that you're going to just ignore the fact that you did that reconsent exercise and market to those individuals anyway. We have heard that happen, not by any of our clients, I might add, but beware, don't do that, please.